So there have been so many changes over the last week regarding H1Bs. Um, so like last Friday, the administration announced that there was going to be an H1B travel ban. They announced this late Friday night, sending everyone in a panic. And basically, when it was first announced, the messaging was that anyone who was on an H1B who was abroad at the moment would be subject to $100,000 fee in order to come back to the US by a certain deadline, which is basically, midnight, September 21st, I believe. So that was a Sunday. So that caused widespread panic among pretty much all immigration lawyers and their clients. And I know of personal friends of mine who actually are on H1B status and who actually had to cancel their travel plans and book a flight to come back to the US before the supposed deadline. Um, and then after the initial uproar, then the administration sent out subsequent messages to the media saying that, no, this is not what we meant to say. This $100,000 travel ban only applies to new H1B petitions. So basically, the next time the H1B lottery opens up in, March, April of 2026. But it was just incredibly confusing and stressful because I don't think the administration really kind of sorted out like how this would apply. But nonetheless, it just caused a lot of concern. And there were attorneys who were gearing up to file lawsuits to try to uh, enjoin or to stop this proclamation from happening. So there's still a lot of questions about how this is going to be rolled out, you know. Um, Is it going to apply to H1B transfer petitions? I honestly have not been following up as much as, when this first came out in the first few days. But there's some questions, I think, as to who exactly is subject to this $100,000 fee. Um, and then later on in the week, there were more changes announced that would affect H1Bs. Now, apparently, there's going to be a new weighted lottery system where um, H1B employees who are being offered higher wages are going to be favored in terms of, the likelihood of getting selected in the lottery. So for those of you who may not know, there are four levels of wages. Um, Level one being the lowest, and then level four being the highest. So basically, the administration said that for employees who are being offered the highest wages, level four, their registration is going to be counted as if it's four entries into the lottery. And so basically, if you're offered a level three wage, which is the second highest, then you're considered to have three entries. Level two, which would be kind of like in the middle, you'd be counted as having two entries. And then level one being the lowest, you would just be counted as having one. So what kind of effect is this going to have on the whole H1B system? It's clearly intended to favor the employers who can afford to pay the highest wages. And, you know, I think that's going to be drastically reducing the number of employers who are financially able to sponsor someone on an H1B. And it's basically going to be um, like a very lopsided system. If only the companies that have the financial resources can participate in the H1B program. This, leaves out small employers. And what effect will that have on the US economy? Um, it's been said that the American economy is basically built on, small businesses and entrepreneurs. So if, let's say I'm a small employer, I'm a solo practitioner, um, and I did sponsor an H-1B employee through my law firm about 15 years ago. We sponsored someone to help us with our accounting, and she worked with us for a few years. If I wanted to sponsor someone today, I don't know if I'd be able to just pay a level four wage to, let's say, if I wanted to hire an associate or a paralegal. Um, so that, I mean, like, it kind of disproportionately negatively impacts small to medium employers if they don't have the unlimited resources now that it apparently requires to be able to sponsor an H-1B. You have the $100,000 fee on top of this, heavily weighted lottery that favors um, the higher paid salary positions. So that's happened this past week. H-1B is a huge topic of discussion. I had a number of consultations this week, um, mostly by students and employees about how this will affect them and their future chances of even being able to be sponsored for an H-1B. Um, and the question is, well, if you're unable to get an H-1B, are there any other ways that you could work in the US temporarily? Are there any other types of work visas that you might qualify for? Um, because the H-1B is the most common type of work visa out there. It's traditionally what most international students who are studying here, once they graduate, they receive employment authorization through practical training. And then the next logical step is being sponsored for an H-1B. Now that's kind of no longer um, being considered as an option by a lot of employers. So then the question is, well, what other work visa is available? Um, it really depends. It depends on several factors, including what is the student's education, what degrees do they have, what major did they study, and also what is the job that's being offered. For H-1Bs, it has to be a specialty occupation. And immigration has already said that they're going to be looking at this question more closely when it comes to adjudicating H-1B petitions. Is the degree related enough to the position that's being offered in the H-1B petition? Um, so, other visa options are out there, but they're not that many. And a lot of them are specific to, what you studied for one thing. Other visas are limited to country of citizenship. So there are visas, for example, that are available to citizens of Australia, Canada, Mexico, Singapore. Um, then there's also the position itself and how qualified and talented the employee is. So I know that there is renewed interest in the O1 visa, which is a visa for extraordinary ability individuals. So if you are working in a field where you have demonstrated that you um, have excellence in what you do and that you've kind of garnered national or international acclaim, um, you might want to look into the O1 as an option. There's two types of O1 visas. There's O1A and O1B. O1B is for individuals who are working in the arts. Um, and O1A is for individuals who are in science, business, athletics, education. So um, there are specific criteria that you need to meet. Minimum of three criteria have to be demonstrated to immigration. And it's not enough to just say that you meet three criteria and therefore immigration will just approve your O1 petition. USCIS will, especially now, they're looking very closely at O1s. And if you're serious about O1 as an option, it's a good idea to do a consultation with an attorney who has filed O1s and has experience in it. Because when you read the criteria, they don't really tell you much as to what evidence you need or what is the level of uh, exactly what kind of evidence would pass muster with immigration. The other advice I would give regarding O1s is, when you read the criteria, every word in that criteria is there for a reason. So, for example, there's a criteria that talks about membership in organizations. It's not enough just to say that you're a member of this or that organization, because that's not what the criteria literally says. It says it has to be membership in organizations that require um, excellence, right? That you've reached some level of recognition in the field in order to be accepted as a member. So don't leave out those crucial details. If you, for example, want to try proving this as a criteria, it's not enough just to just say, here's my membership card to this organization, right? Immigration will want to know what is this organization's written criteria for being accepted as a member. Is it on the organization's website? It should be. If it's not, then you'll have to find a way to obtain the exact specific criteria to be a member, because immigration will ask for it if you don't provide it. And if it's written, the membership criteria, you can be sure immigration is going to read it and then make this assessment of, okay, well, how difficult is it to be a member of this organization? Do you just pay an annual membership fee? Do you just need to show that you have like a certain minimum level of education and X number of years of experience? If those are the only criteria, then I would say, well, it doesn't seem like it's that difficult to uh, become a member. Um, Also, I would say that if the membership criteria um, is a little vague, then that also is ripe for critique by immigration. They want to know exactly what is this process, who reviews your application for membership, how is the decision made to offer membership to somebody, um, how exclusive or how competitive is it to become a member of this association. So that's just an example of how immigration reviews criteria that are claimed in ON petitions. They really go through everything with a fine-tooth comb. Another criteria that they love to kind of take apart is, let's say, if you are using the criteria that you have press or media about you in major media, it's not enough to just say, oh, I was interviewed in this, in this magazine. They're going to question whether or not that magazine qualifies as major media. They're going to ask about circulation statistics. How influential is this publication? I have reviewed RFEs, which are requests for evidence from immigration in response to ON petitions that I filed, where one USCIS officer claimed that there was no proof that the New York Times was counted as a major newspaper. So don't be surprised if immigration, that's their reaction. I don't know if those types of questions are because the officer honestly has never heard of the New York Times, or if they're just being um I don't know, like pedantic or difficult, right? If let's say the officer may very well know what the New York Times is, but you haven't like given a background explainer on what the Times is, how long have they been around, what is their circulation like, how many awards has the Times received in, journalism and reporting. I mean, who knows the intent behind these RFEs? But, just be prepared that if you do decide to file an O1, that this is the level of explanation that you sometimes have to go through with USCIS.